Hello everyone, this is Tanushree Chowgle and you're watching Ganga Education. Welcome back to my channel. On this channel, you will get information relating to law, and if you are looking for some competitive examination related to law, then you are on a right platform. I have done some videos in past on those topics also. I am going to drop links for you in the description box below. Now let's continue with our today's topic. In this video, we are going to solve Civil Judge Junior Division and Judicial Magistrate of First Class Preliminary Examination held in 2017 at Maharashtra. Previously, we have solved question papers of Civil Judge Junior Division and Judicial Magistrate of First Class Preliminary Examination held in 2011 to 2016. You will get the links of those videos in description box. Please go through them also. This video series will be in 4 parts. We will discuss 25 questions in each video. For this video, we will solve question number 1 to question number 25. So let's get started. This is question paper of Civil Judge Junior Division and Judicial Magistrate of First Class Preliminary Examination held in 2017. This is set A. We have already discussed the instruction for the candidates while discussing Civil Judge Junior Division and Judicial Magistrate of First Class Preliminary Examination held in 2011. So we are not going to discuss these instructions here. Let's jump on question number 1. Question number 1. Remedy of rectification is available under section 26 of the Specific Relief Act related to option number 1, mistake in expression of contract only. Option number 2, the contract itself, that is the formation of contract. Option number 3, addition of the term in the agreement which was not considered. Option number 4, matter which were overlooked by the parties. And the correct answer is option number 1, mistake in expression of contract only. Now question number 2, relief of rescission is granted in cases. Option number 1, when the contract is void. Option number 2, when the contract is voidable. Option number 3, both void and voidable contract. Option number 4, neither void nor voidable contract. And the correct answer is option number 3, both void and voidable contract. Now question number 3. Section 12 of the Specific Relief Act permits grant of specific performance of part of contract. Option number 1, where the part left unperformed bears only small portion of the whole in value and admits of compensation in money. Option number 2, where the part left is the substantial portion of the whole in value and admits of compensation in money. Option number 3, where the part left unperformed is a small portion of the whole in subject matter and does not admit of compensation in money. Option number 4, none of the above. And the correct answer is option number 1, that is where the part left unperformed bears only small portion of the whole in value and admits the compensation in money. Now question number 4. Court is not bound to grant specific performance of the contract merely because it is lawful to do so and can properly exercise discretion not to grant decree for specific performance of contract if option number 1, contract though not voidable gives plaintiff unfair advantage over the defendant. Option number 2, where performance of contract would involve more hardship on the defendant which he did not foresee than the hardship to the plaintiff. Option number 3, both 1 and 2 are correct. Option number 4, both 1 and 2 are not correct. And the correct answer is option number 3, both 1 and 2 are correct. Now question number 5, where premises are let out for residential purpose and tenant dies, who amongst the following can be termed as a tenant under section 7 subsection 15 of the Maharashtra Rent Control Act 1999. Option number 1, members of tenant's family whether or not residing with him. Option number 2, member of the tenant's family residing with him. Option number 3, 1 and 2 above. Option number 4, none of the above. And the correct answer is Option number 2, that is member of the tenant's family residing with him. Now question number 6. Choose the correct option. 1. Maharashtra Rent Control Act 1999 shall not apply to any premises belonging to government or local authorities. 2. The Maharashtra Rent Control Act 1999 shall not apply to the public limited company having paid up share capital of less than 1 crore rupees. Option number 1, first is correct, second is incorrect. Option number 2, first is incorrect, second is correct. Option number 3, both are correct. Option number 4, both are incorrect. And the correct answer is option number 4, both are incorrect, means those given options are incorrect. Now question number 7. In a contract of guarantee, option number 1, there is a promise to the principal debtor to indemnify the surety. Option number 2, there is an implied promise by the principal debtor to indemnify surety. Option number 3, there is a promise by the surety to indemnify the creditor. Option number 4, none of the above, and the correct answer is option number 2, there is an implied promise by the principal debtor to indemnify surety. Now question number 8, where a contract to give time to the principal debtor is made by the creditor with the third person and not with the principal debtor, the option number 1, surety is discharged. Option number 2, surety is not discharged. Option number 3, surety is discharged at option of principal debtor. And option number 4, none of the above, and the correct answer is option number 2, surety is not discharged. The question number 9, A and B agree that A shall pay rupees 1000 to B, for which B shall afterward deliver to A either rice or smuggled opium. Option number 1, this is void contract. Option number 2, the contract is voidable at the option of A. Option number 3, this is valid contract to deliver rice and a void agreement as to the opium. Option number 4, the contract is voidable at the instance of B. And the correct answer is option number 3, this is a valid contract to deliver rice and a void agreement as to the opium. Now question number 10, which one of the following is not correct? Option number 1, agreement in a restraint of marriage is void. Option number 2, if the consideration and object of the agreement is unlawful in part, agreement is void. Option number 3, agreement in restraint of trade is not void. Option number 4, agreement in restraint of legal proceeding is void. And the correct answer is option number 3, agreement in restraint of trade is not void. We have to find the sentence which is not correct. Now question number 11, decree shall be deemed to include the rejection of plaint and determination of any question within the meaning of section 144 of the Civil Procedure Code. Option number 1, wrong. Option number 2, right. Option number 3, it includes rejection of plaint but does not include determination of any question within the meaning of section 144 of the Civil Procedure Code. Option number 4, it includes determination of any question within the meaning of section 144 of Civil Procedure Code but shall not include the rejection of plaint. And the correct answer is option number 2, the given sentence is right. Now question number 12, whether an issue heard and finally decided by a competent court of limited jurisdiction shall operate as res judicata in a subsequent suit, notwithstanding that such court of limited jurisdiction was not competent to try such suit. Option number 1, no. Option number 2, yes. Option number 3, answer would depend upon the nature of the suit. Option number 4, none of the above. And the correct answer is option number 2, yes. Now question number 13, the provisions of res judicata also apply to the execution proceeding of a decree. Option number 1, true. Option number 2, false. Option number 3, res judicata only applies to suits. Option number 4, do not apply if objection is not raised by judgment debtor. And the correct answer is option number 1, true. Now question number 14. Under which provision of Civil Procedure Code is a suit to set aside a decree on the ground of lack of territorial jurisdiction barred? Option number 1, Section 21 of Civil Procedure Code. Option number 2, Section 21A of Civil Procedure Code. Option number 3, Section 22 of Civil Procedure Code. Option number 4, Section 37 of Civil Procedure Code. And the correct answer is option number 2, that is Section 21A of Civil Procedure Code. Now question number 15. A person detained in civil prison in execution of decree can be released before the expiration of period of detention order. Option number 1, on payment of entire amount for which warrant is issued or on decree being otherwise fully satisfied. Option number 2, on request of decree holder on whose request warrant of arrest is issued. Option number 3, for non-payment of subsistence allowance by the decree holder. Option number 4, all the above. And the correct answer is option number 4, all the above. Now question number 16. In a civil suit where a decree is silent as regards future interest shall be deemed to have been refused and a separate suit shall not lie. Option number 1, true. Option number 2, false. Option number 3, partly true. Option number 4, none of the above. And the correct answer is option number 1, true. Now question number 17. Where defendant is confined in prison, the suit summoned shall be served upon him. Option number 1, by affixing outside prison. Option number 2, by sending process server in the prison. Option number 3, by delivery of the summons to the officer in charge of the prison for service on the defendant. Option number 4, by issuing production warrant through court. And the correct answer is option number 3, by delivery of the summons on the officer in charge of the prison for service on the defendant. Now question number 18. An aggrieved informant on a refusal on the part of officer in charge of police station to record information regarding cognizable offence may, option number 1, make complaint to Judicial Magistrate First Class. Option number 2, make complaint to Chief Judicial Magistrate. Option number 3, make complaint to the district judge. Option number 4, send a writing substance of the information by post to the Superintendent of Police. And the correct answer is option number 4, send in writing substance of the information by post to the Superintendent of Police. Now question number 19. For offence punishable with fine only, the period of limitation for taking cognizance is option number 1, 1 year. Option number 2, 6 months. Option number 3, 2 years. Option number 4, 3 years. And the correct answer is option number 2, 6 months. Now question number 20. As per section 357 of Criminal Procedure Code 1973, order to pay compensation can be passed. Option number 1, when sentence of fine only is imposed. Option number 2, when sentence including a sentence of death of which fine forms a part is imposed. Option number 3, when sentence of which fine does not form part is imposed. Option number 4, all of the above. And the correct answer is option number 4, all of the above. Now question number 21. Under the Code of Criminal Procedure, service of summons can be made on any person other than a witness. Option number 1, by registered post. Option number 2, by courier. Option number 3, by affixing a copy on the house. Option number 4, none of the above. And the correct answer is option number 4, none of the above. Now question number 22. The compounding of offence under section 320 of Criminal Procedure Code before framing of charge shall have the effect of option number 1, discharge. Option number 2, withdrawal of case. Option number 3, permission of court. Option number 4, an acquittal. And the correct answer is option number 4, an acquittal. Now question number 23. For the purpose of period of limitation under section 468 of Criminal Procedure Code, the period of limitation in relation to the offence which are tried together shall be determined with relevance to. Option number 1, the offence which is punishable with the more severe punishment. Option number 2, the offence which has the most severe punishment. Option number 3, 1 and 2 both. Option number 4, none of the above. And the correct answer is option number 3, 1 and 2 both. Now question number 24. Section 129 of the Indian Evidence Act 1872 states that no one shall be compelled to disclose to the court any confidential communication which has taken place between. Option number 1, husband and wife. Option number 2, company and its clients. Option number 3, legal professional, advisor and his clients. Option number 4, doctor and patients. And the correct answer is option number 3, legal professional, advisor and his clients. Now question number 25. Under section 114 of the Indian Evidence Act 1872, court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of. Option number 1, natural events. Option number 2, human conduct. Option number 3, public and private business. Option number 4, all the above. And the correct answer is option number 4, all the above. That's it for this video. In upcoming videos, we will solve remaining 75 questions. So stay tuned and thank you for listening.